Welcome, everyone, to the ICNC webinar series. We are so glad to have each of you join us. Today, we are discussing a new publication that I think you will find really fitting for our times in many countries around the world. And it's concerned with judicial independence and what judges and their allies in the legal community, but also just in their home nation, can do to secure freedom and independence from authoritarian overreach. Today, we are celebrating the release of this book. It's called All Rise, Judicial Resistance in Poland by Dr. Marcin Morawiecki. And please correct me if I mispronounce your name, my friend. But we are so glad to hear from you today as you present the findings of your book, the lessons learned from the innovations of the judicial community in Poland. And we are also joined by legal experts from North America and Africa. And let me share with you a proper introduction of each of our speakers. Dr. Marcin Morawiecki is assistant professor of the European Union Law and Human Rights at the University of Warsaw, the Center for Europe. He is an author of many academic and popular science publications. He worked as a lawyer at the European Court for Human Rights in Strasbourg from 2012 to 2016, and at the Polish Commissioner for Human Rights Office in Poland from 2016 to 2024. Since February of this year, he's also a secretary of the Interministerial Committee for Restoring Rule of Law and Constitutional Order, and a deputy head of the Criminal Law Department at the Ministry of Justice in Poland. It is from this wealth of expertise and also his knowledge and access to so many judges and lawyers in Poland that he was able to carry out the interviews that formed the basis of this study. Our respondents today are Elizabeth Wilson and Doug Coulthard. Elizabeth A. Wilson has a JD from Harvard Law School and a PhD from the University of Pennsylvania. She has taught public international law and international human rights at Seton Hall's School of Diplomacy, Rutgers Law School, and Columbia University's Institute for Human Rights, and has been a visiting senior fellow at the Max Planck Institute for Comparative Public Law and International Law in Heidelberg, Germany. She is the author of People Power and International Human Rights, Creating a Legal Framework, which I have right here. This was ICNC's first monograph that dealt with legal matters. And she is now an attorney with Gilbert Employment Law, a civil rights law firm. Our second respondent today, Doug Coulthard, is a Zimbabwean lawyer, human rights activist, and social movement coach and writer. His legal practice focuses on providing representation to journalists, activists, trade unionists, and others who are prosecuted for exercising their rights. So it is with this that we turn our attention to Marcin. Marcin, we look forward to hearing from you. Please lead us through the story of an amazing act of resistance from the judicial community in Poland and what we can all learn from our legal communities and ally communities around the world. Thank you. All right. I think that we should have them in the room just now. One moment. Great. Thank you, Marcin. I've just finished introducing you, and we look forward to hearing about the incredible study that you've done. Thank you.
I've heard. Can I share my presentation?
Yes, you should be.
Okay. Thank you very much. I'm now in Tel Aviv, Israel, where I'm continuing my interest in resistance against judicial overhaul here on the spot, and I'm fascinated by what Israeli lawyers and law academics they did here. And when I was presenting judicial resistance in Poland to them, they said this whole story is fantastic, and not fantastic in a way amazing, but fantastic in a way. It's a fantasy to imagine judges protesting in such an organized way, in such, we can say, unprecedented way, even on the streets, against threats to their independence. So let me show you the presentation, and let's start with the rule of law crisis in Poland. I'm aware that most of you know what was the crisis, but just to make sure we're all on the same page, let me show you what happened. Yes, and it also shows that there is a certain kind of populist playbook according to which all populists play. So first of all, between 2015 and 16, the Constitutional Tribunal was taken over in Poland. Yes, so what happened was basically, first of all, there were some illegally appointed judges that were seated in the Constitutional Tribunal, and then what happened? It was packing politically connected members of the Constitutional Tribunal within years. It turned out that the constitutional protection safeguards were switched off. And this was what happened in 2015 and 16, and Poland was taken by surprise because nobody believed that it could happen. But in 2017, the Ministry of Justice presented 3 new acts that were aiming to completely amend the law on the ordinary courts, on the Supreme Court, and on the National Council for the Judiciary that is responsible for appointment of judges, among others. And this is the moment when, and this is also the turning point for many judges that were very passive so far, because they realized that this is their turn. After the Constitutional Tribunal, it was their turn to be taken over. Yes, so this is when the protest started. And of course, it led to, I will be talking about it in the end, about what was the impact of the resistance, but 2 of these acts, because of the large protests all over the country, were vetoed by the president. But one of them was enacted, and it led to, among others, dismissals of presidents and deputy presidents of courts. So they taken over the courts, then the National Council of the Judiciary. Finally, they started disciplinary proceedings against, or even criminal proceedings against those judges who protested against judicial overhaul. So this is basically a very short presentation of what happened in Poland. And having said that, my research consisted of certain questions about emergence of resistance, about the previous experience in resistance of judges and lawyers, change of stance towards rule of law crisis, what was the nature, I mean, what were the boundaries of what a judge can do to resist. The question was also if a judge can break a law to defend judicial independence, and if the judges perceive themselves to be members of the resistance movement, and what was the impact of the resistance, and what kind of changes should stay after the rule of law is restored. And in order to get answers to those questions, I interviewed 27 judges, 2 prosecutors, 11 lawyers and activists, and 2 academics. Most of them, like all of them, remained anonymous, and it was like a part of agreement between me and them. But some of them said that it's not a problem to be quoted under their names, but I decided to protect the anonymity in this case, and that's why you will see in the monograph Judge 1 to 27, Prosecutor 1, 2, etc. Yes, so this was the interviews, and I was doing it during COVID. Yes, so I had a lot of time at home, and most of them were done by Zoom. So what kind of judges were involved in the resistance? It's also interesting to see that mostly they were 40 plus, because those under 30, they were first of all stuck with work in the district courts. They had children to raise, credits to pay. They didn't want to be involved in resistance. Also, judges who were close to their retirement age were very passive, because we can imagine like this threat of losing this benefit of retirement. 10% of judges were skirmishers, 70% moderate, those who try to survive, and 15% of judges supported Law and Justice Party that that was acting in order to take over judiciary. Yes, and whole taxonomy was made on the basis of Michael A. Beer division, that he divided resistance behavior into saying, not doing, or doing or creating, and even within the nature, what could be like confrontational or constructive. So we had different types of behavior, that so the whole actions were divided into this kind of division based on the Michael A. Beer idea. And I would like to show you the most important ones. We don't have time for more. I think the book, in the book even, I don't think we have everything, but the most important actions. So this is one of the most symbolic one, because it was already in July 27. It was one of the very first for most of the judges. It was in July 2017. It was so-called chain of lights against the amendments of the law concerning common courts and the Supreme Court, and also National Council for the Judiciary. And for most of the judges, it was the turning point. They saw people protesting protesting against this judicial overhaul, but they also realized that there was a gap. Because people wanted judges to speak up and to say something what in fact is happening, to understand the situation. So here you can see the photo from the March of Thousand Goals, and I will only want to tell you how difficult for most of the judges was to come out from the court and to protest on the streets in the Gome. Like within the code of the professional conduct, this kind, like leaving the hearing room in the Gome is perceived as a disciplinary delict. So for most of the judges, it was like unimaginable to go out from the court, but most of them like decided to show during this protest, and to express the protest against the muzzle law. Yeah, so this is very symbolic, and for many judges, if you talk with them, it was one of the turning points. Also, in the way that they saw how many of them were participating in the protest, but also other professions and also judges from other countries. This is another protest, judges protesting in front of the courts every 18th of day of every month at 12 in solidarity with repressed judges. You could see judges going outside the court and protesting, showing solidarity with those who were repressed. Repressed meaning that the disciplinary or criminal proceedings even were initiated against them, and also most of those judges were already suspended with the salary cut, like 50%. So it was really important to show solidarity. Yes. Also, this is the action with the T-shirts with with the word Constitution. It was after one of the judges was repressed because she was wearing one of them. So to show solidarity, every judge wore this kind of the T-shirt. Yes, and it is in front of one of the courts. So all judges, they gathered together, they took this photo and sent it. It was via Facebook. So to show the solidarity. Yes, and here, this is for Igor Tuleya, You Will Never Walk Alone. judges in solidarity showing, I think it's from in front of the Krakow court. So you can see how many judges in gowns protesting against repressions against Igor Tuleya, who had even criminal charges against himself. Yes, so this is it. And this is the protest of judges against the muzzle law. So we had acts of expression using the medium of human body, material arts, digital technology, and human language. This was the first one. So you could see most of them on the pictures, but also there were like standing with letters forming names of the prosecuted judges, Black Friday protests in front of the courts, attending disciplinary proceedings related to repressed judges and adjudication of neo-judges. So it was also important to show solidarity with those who were persecuted and to go and to see what the disciplinary judges were doing during the hearing, running in solidarity with repressed judges or gathering of judges in front of the Supreme Court during indictment. Another medium is material arts. So you have seen the Constitution t-shirts, but also there were many posters hanging up in the courts, decorating symbolic Christmas tree in the courthouses, distributing and placing stickers and name tags, placing stickers in court windows, or shaming candidates to the National Council for the Judiciary. Then the digital technology that was really important in judicial resistance, because there were certain blogs where judges expressed their ideas about the ongoing so-called reform of the judiciary. There were podcasts, but also YouTube videos, social media and messaging apps. And those messaging apps via WhatsApp were really crucial. And using the government's centralized email system was also important to communicate between judges in order to protest or organize protests. Then we have human language, and we have resistance through writing, open protest letters, letters to an international organization, press articles, awareness raisings, and resistance education during festivals, even using the academic pulpit as professors, because many of judges are also academics, judges in schools, because judges realized that there is a need for constitutional education once the Constitutional Tribunal was taken to, because one of the reasons it all happened was like lack of basic education concerning constitutional laws. Yes, so then outreach to domestic mainstream media. Justitia, one of the biggest judicial association, had its media team that was really credible that the foreign media outlets were approaching the Justitia asking for information. It was BBC, it was CNN, and other very reliable media outlets. Yes, so this was also very important to see that how many levels were here touched. And then we have acts of omissions and as political or judicial non-cooperation. And one of these was already shown on the picture. No court hearing day, every 18th of the month was the day of the solidarity with repressed judges. So there was no hearing, judges rescheduled those hearings. And also they refused to adjudicate with politicized judges sitting on the same bench. They boycotted putting forward candidates to National Council for the Judiciary. And also they didn't take part in any competition for promotion. They boycotted, they also refused to give opinion on candidates to the National Council for the Judiciary, refused added duties, or disobey unjust law, which was happened during the COVID times. They refused to apply those unconstitutional laws that were enacted during the COVID time. Then also they refused to reveal the association or memberships connections, but they refused to go on strike. They said it would be against the citizens, because every citizen has the right to a fair trial. They should have an access to court. That's why they refused to go on strike. And there were also acts of omission as social non-cooperation. They didn't participate in judicial disciplinary proceedings, but they refused to resign. I talked only with 2 judges that resigned, and most of them said that it's better to be within the system, because having as a judge tools, like most of them were legal tools, was much more it was a much better position than not being within the system, not being a judge, and they could use all possible legal tools in order to protest. One of very interesting tools was ostracism. It was not shaking hands with so-called neo judges that were doing careers during this time, and also not saying hello, not having any relationship with these people, showing that what they did was not accepted in the judicial community, and also withholding common signs of respect for the neo judges, or refusing to call neo judges president, etc. Then we have the political judicial disruptive intervention. It was, for example, kamikaze strategy, that was taking part in judicial promotion competition in order to question it afterwards before the national and then European courts. And some of these kind of actions that they turned out to be very successful. I mean, in a way that now we have the European Court of Justice and European Court of Human Rights case law concerning judges. Then we have disclosing recording of the National Council of the Judiciary competition, brief work stoppage during case hearings, halting a hearing to explain resistance, even self-denunciation. That was also very interesting, because judges, when one of them was chased by disciplinary spokespersons, they said they did the same delict that the one person was chased for. And for example, 80 judges, they signed a statement that they should be also disciplined for the same behavior that was already a subject of the disciplinary proceedings. Then we have political judicial creative intervention, like, for example, dismissal of a court decision on the grounds of the illegitimacy of a judge appointed by the National Council for the Judiciary, challenging constitutionality of the regime, submitting preliminary questions to the European Court, use of legal opinions, lawsuits and complaints by resisting judges, and gathering information and archiving. And it is also important to see that most of these tools were legal tools. So judges used the opposition in order to protest. And also there was an economic creative intervention, like creating an option for financial resources and legal aids for the repressed judges. It was, and also prosecutors. It showed not only the solidarity, but it helped financially those judges whose salaries were cut and who didn't work during that time. Yes, they also provided legal aids to prosecuted judges. It was a sign of solidarity and important help. Social creative intervention, we have here establishment of foundation of legal education. I've already told you that judges realized that legal education is a crucial element. So they started the legal education, and one of the very important tasks were to provide expertise in those constitutional matters, and raise awareness events, and also to the Constitution, so-called. To the Constitution was about to promote values enshrined in the Constitution, but also to make people aware of what is in the Constitution. Then psychological creative intervention, we have not expression of solidarity in a psychological aid, that was very important, small gestures of kindness, signature drive, psychological support, solidarity with repressed prosecutors that were even in worse situation because of this subordination obligation, and solidarity service. So to sum up, like this book finishes with takeaways for judges, because this is important to understand what was the reason. One of the reasons that those attacks started was that the behavior of judges in the courtrooms. Yes, so one of the takeaways is for judges is to transforming into people's judges to connect more effectively with ordinary citizens, and judges must change their attitude in the courtroom. And they have also duty to uphold the judicial oath and engage in judicial disobedience when necessary. And independent judges can resist populist changes in the judiciary by adhering strictly to the Constitution and international law. This is something that they didn't do at all before. They were like mouthpieces of legal acts. And then they realized that without constitutional tribunal, they themselves have to apply the Constitution and international law. And judges should utilize all procedural opportunities, ensuring no case is overlooked. There are other takeaways. One of them is using media and communication of channels, also social media platforms such as Facebook and Twitter. But what was very important, internet communication platforms such as Viber, Messenger, WhatsApp, ProtonMail, and Signal to maintain the communication. There were so many groups created on WhatsApp in order to communicate and to exchange, even during, for example, disciplinary proceedings, to exchange the lawsuits or the appeals against, and it made it very effective. And resistance means staying in office rather than resigning, because there is not much help in resigning in this case, and judges should initiate informal dialogues with international entities, and judicial associations are crucial in resistance. So there are also takeaways for lawyers, because they also took part in judicial resistance, and you have to be aware that it was possible because of the involvement not only of lawyers, but also of the civic society organizations and also of people that protested on the streets. So for lawyers, I would say that establishing a central platform is essential for coordinating strategies among judges, prosecutors, attorneys, and civil society representatives. It happened, we had something like a committee of defense of justice that were coordinating all actions of lawyers. And it is natural that all legal professions should become active, and involving judges and lawyers from other EU member states is crucial. Law academics shall do more for resistance of judges. This is what happened in Israel, for example. And reaction to the attack on the rule of law, independence of court should be immediate, because according to the populist playbook, there is no time to wait. And what was the impact of judicial resistance? This is the last slide. So first of all, the judicial resistance slowed down the judicial overhaul, because what was missing so far was the narrative of judges that would provide what in fact would happen if those reforms would be enacted. Yes, and also judges realized that they cannot be silent in this case. And what was crucial, that Polish resistance became a European concern. So we have the actions of the commissions that started the so-called nuclear weapon Article 7 of the treaty procedure, and also we have now very rich case of the Court of Justice of European Union and the European Court of Human Rights. Even there is this pilot procedure on the basis of the case Wałęsa versus Poland that obliged Poland to restore rule of law. And because of that, we have a rich case law concerning judicial independence, the case law that is also the basis for other countries to use against such an attempt to take over judiciary. And also judges engage citizens. It is very important to raise awareness of the rights that are enshrined in the constitutions or international law that are connected with right to access to independence, impartial court. And politicians also learned what was at stake. So one of the impact was that in 2023, the election was won by the democratic opposition. So this judicial overhaul was stopped in 2023. And also persecuted judges came back to work. This was also very important to see that those judges who were suspended, they finally came back to work and they could be judges afterwards. And the legal professions came together. The solidarity was really one of the most important ideas behind the whole judicial resistance. And it also pierced the opponent. We had situations in which so-called neo-judges, they wanted to sign letters with solidarity of some repressed judges like Judge Iwulski, or they also wanted to sign the appeal that to obey the EU law. And one of the most powerful impact of judicial resistance is inspiration for others. I think this is something that is spoken about and everybody's aware of what happened in Poland, and that populists could be stopped by such resistance. And now I can see in Israel that here judges didn't have to protest because there were lawyers who did the same what did Polish judges. Thank you very much.
Thank you, Marcin. This is so deeply insightful, and I know that our community is eager to discuss this. We're going to turn it over to Doug Coltart, a Zimbabwean lawyer and movement coach. And we're interested, Doug, in your reflections on both the study and this presentation.
Sure. Thanks very much, Marcin, for the presentation, and to ICNC for hosting this. And yeah, really a huge congratulations to you, Marcin, for an excellent piece of research, which I think is quite a significant contribution to the field of civil resistance research generally, and a fascinating case study on particularly the role of judges and the kind of centrality of the courts. So yeah, and one that I think has been really beneficial to me, even in a very different context. So I'm a lawyer based in Zimbabwe, which is an authoritarian state as opposed to a sort of a backsliding democracy. And yet, even in such a different context, there's so much that I have been able to glean from your research. So, in terms of how I'll, the kind of remarks that I'll give, I'll try to draw out some of, I think, the general principles that I've seen in your research, which I think may be more broadly applicable to those grappling with some of these issues elsewhere. I think one of the most striking things for me initially upon reading it is the long-term impact of previous civil resistance struggles. This is something that Chenoweth and Maria Stefan have written about, the long-term impact that a civil resistance struggle can have, but how the muscle memory and culture that was developed decades prior, with the solidarity movement, then kicked into gear again decades later when democracy was threatened and judicial independence was threatened. And I think it's a really fascinating case study of what that looks like. And it's interesting. It's backed up by a fascinating quantitative study that actually Hardy Merriman from ICNC first put me onto, by 3 authors published in 2002. The piece is called "The Tactics of Resistance and Post-Conflict Judicial Independence." And one of the key findings of that is that judicial independence is significantly higher in a post-conflict society where the tactics used were nonviolent resistance as opposed to violent resistance. And what's particularly fascinating is that even in cases where
Well,
Oh my
we lost Doug. He did mention beforehand that he was having some connectivity issues. And he was right on the crux of a brilliant thought. But we expect that he will return, hopefully.
Oh, there you
can
nope.
you hear me?
Oh, yes, we can hear you. Wonderful. That was
Apologies about that, everyone. Just the joys of Zimbabwean internet connections. But yeah, so I was talking about the study, and the fascinating aspect of it is that even where the nonviolent movement failed to achieve their success, that it still had it was the tactics themselves that actually had the long-term impact on judicial independence. Of course, the solidarity movement in Poland was successful, but I think it remains a fascinating example. And I think what it then creates is a kind of a baseline judicial independence, which I think is really, in the pre 2017 Polish society, which then becomes, I think, a really critical component for this type of judicial resistance from judges themselves, which I think might not be possible in kind of more entrenched authoritarian societies, such as Zimbabwe or other more entrenched authoritarian societies, where the kind of judicial independence is so far gone that there isn't even the desire on the part of judges to resist encroachments on their own independence, which I think brings me to the kind of the next broad point from that I draw from your research, which is that the importance for pro-democratic actors to strike while the iron is hot, as judicial independence is threatened. And I think this is a point that is likely to become increasingly relevant even in kind of more established democracies, but where there are these populist currents.
Disappeared again.
Thank you to our wonderful community attendees who are patient with us. We're holding our breath for his return and thoughts. Good to have you back, Doug.
Apologies for that. I'm just trying to move to a different location.
Not a problem. But you were sharing that, this is a time where it's increasingly important even for sort of long established democracies.
Exactly. And so I think it's another really valuable contribution. But I think across the board, whether we're talking about declining democracies or entrenched authoritarian states, I think there are several really valuable key kind of lessons. I think one is that courts are always going to be a site of struggle in every democratic struggle, and where courts are a site of democratic struggle. One thing which I see emerging from your research and from my own experience and research is the necessity of litigation in courts, particularly in compromised courts, to be complemented by nonviolent action, broad-based movement building, in order to counteract the top-down pressure that is placed on compromised judiciaries to give an unjust outcome, to essentially counterweight that with a bottom-up pressure from citizens in order to try to extract a more just outcome, even from compromised courts. And in that context, I think the phenomenal case studies of the acts of solidarity that are documented in your paper become really critical. The solidarity between judges within the profession, solidarity from the legal profession towards the judges, And then the solidarity from the breadth of Polish society, and of course the international community as well. And I think that this is an aspect that authoritarian regimes are increasingly understanding the significance of solidarity. What we are seeing in Zimbabwe is the criminalization of solidarity. Anyone who stands, attends court or shows any kind of solidarity with those who are persecuted by the regime, then end up being arrested simply for that act of solidarity and prosecuted for that. But even in that, there's been valuable lessons that I've drawn from your paper. The creative tactics that were used. I love the example of the empty suitcases that were left outside the court to tell the neo judges to pack their bags and go. It's the type of tactic that can be used even low risk. The suitcases end up doing the protesting for you rather than people in a high risk context. And the last thing that I would say is just in closing, which I think was impactful for me as a lawyer practicing in this context, is really thinking through the role of lawyers in the struggle for judicial independence and democracy. And it's incredible to see the breadth of roles that lawyers played as documented in your piece. Of course, providing legal representation pro bono to the judges, which is kind of the mainstay of and what we kind of think of as lawyers. How can we help? But then when you see the breadth of other things that lawyers did, it's quite striking. The public education videos breaking down what was really going on for ordinary citizens in a way that they could understand, and in perhaps a way that sometimes judges are not able to always do themselves, in their own cause. The education of children. I was astounded to read, how they managed to mobilize around 600 lawyers to educate around 30,000 children on constitutional law. And that really is something that can have a very long-term impact on judicial independence, human rights, constitutionalism in Poland, and I think for those of us seeking to learn from that example in our societies as well. And then, of course, the organizing role that lawyers played, working, of course, in close connection with judges and civil society more broadly. But the role that lawyers can also play in organizing marches, demonstrations, various forms of nonviolent action is both inspiring and instructive. So yeah, I'll leave my remarks there. But in closing, just to say thank you very much for a really groundbreaking contribution to the literature, and for really reminding us of the centrality of judicial independence for the broad struggle for democracy throughout the world. So thank you.
Thank you, Doug. Very insightful comments, and we appreciate your perspective both as a lawyer and as an advocate within the activist space in Zimbabwe. We turn now to Elizabeth A. Wilson, who I already introduced at the beginning, but as a reminder, she holds a JD from Harvard Law School and a PhD from the University of Pennsylvania, and she authored the study People, Power Movements and International Human Rights, Creating a Legal Framework, which I highly recommend for all of you interested in this intersection of movement work and legal work. Elizabeth, we already began some rich discussions before this on the implications of this within the American context, and I'm curious about your thoughts on this study. I'll turn it over to you.
Thank you, Bruce. And can you hear me okay? Because we didn't have time to do a sound check. Great. Okay, and I am really sorry that I could not hear pretty much anything that happened before this moment. I heard at the end of Doug's comments, but I thoroughly enjoyed the monograph. I thank you for this work. It's incredibly important. And as somebody who has been thinking about law and movements for some time, it's really a valuable contribution. I'm going to start just by putting out 3 questions that I have. There were general questions to the monograph, and then I'll turn to like the thoughts I had about what this means, what the implications might be for the US system, or how does this analysis look if you translate it to the United States. So my 3 general questions are that I noticed the key role that the appeals to the European Union courts and the EU, the Court of Justice of the European Union and the Court of Human Rights, as well as demonstrations by the public. And I wondered if you had any thoughts on how to allocate the effectiveness of the judicial resistance in Poland as opposed to the pressure coming from the EU, and particularly their ability to enforce judgments against Poland by the mechanism of the freezing of the funds, the COVID relief related funds. And that versus the judicial resistance within Poland versus the public demonstrations of support. That's one question. Another question was that I noticed that there was a strong position taken by the judges in this study against resignation as a response to authoritarian power grabs. And I thought that that seemed like it was evidence that there was still some kind of faith left in the system, and that working within the system could be efficacious. So I'm just wondering, would there have been a point where this faith would have been lost and where resignation would have become seen as a more ethically preferable thing to do? And where would one locate that point? And then the third question is that the monograph in a very brief section makes a point about the role of positivism and how that functions as a kind of disincentive to activism, or like extrajudicial activism with respect to judges, that the pressure that positivism gives to kind of obey the letter of the law, no matter what it may be, no matter how it is trending in terms of like justice or fairness. But the traditional counter to positive law is natural law, which is beset by a lot of problems and often associated with conservatism. So I'm just wondering if you have any thoughts on countering the problem of positivism that might avoid the problems that we associate with natural law. Okay, so now I'll turn to the United States. And it was really a very interesting experience for me to read this monograph and thinking about our judicial system versus the system that the judges were struggling with in Poland. And the thing that, the initial thing that struck me was the National Council on the Judiciary, if I got the name correct, the NCJ. I was like, what a concept. I mean, in principle, what a concept. A body whose purpose is to secure the independence of the judiciary. Because even in, in its uncorrupted form. Like if you take away any kind of authoritarian pressure, the pure form of judicial nomination process in the United States is much more like the compromised post Law and Justice influenced NCJ than it is like the constitutionally established NCJ in the Polish, in the Polish constitution. So in our constitution, in the United States Constitution, I won't say our, but I shouldn't say our. It's the case that the president is entrusted with the nominations to the judiciary, to the federal judiciary. The state's judiciary is a different matter, of course. And so in situations where the president and the Senate are both controlled by the same party, that is, if the president is a Republican and the Senate has a Republican majority, there are almost no guardrails on the de facto politicization of the process. So what we learned in our recent experience with the first term of the Trump administration was the extent to which United States institutions depend, to an extent that we didn't even realize, on the goodwill of those occupying positions of power. And so the Constitution of the United States gives the power to the president, and with the advice and consent of the Senate, to nominate appointees to the federal judiciary. And I just want to read an excerpt from a report done by the Congressional Research Service, and this is the research body that gives research to members of Congress on demand, and they did a report on how federal judges are nominated, and this is how it describes the process after the constitutional guidelines are set out. With almost no formal restrictions on whom the president may consider, an informal requirement is that judicial candidates are expected to meet a high standard of professional qualification. By custom, candidates whom the president considers for district judgeships are typically identified by home state senators, and some more detail on that. And another customary expectation is that the administration, before the president selects a nominee, will consult both home state senators, regardless of their party. Now, so there's a lot of, by custom and tradition here. And what has happened in the United States, beginning with the Reagan administration in 1980, and the formation of the Federalist Society in 1982, the Federalist Society is a very well-funded activist group that has long had its goal of taking over the federal judiciary and filling it with like-minded, philosophically conservative justices. And beginning with Reagan's Department of Justice, but even more so in George W. Bush, George Herbert Walker Bush, and then George W. Bush, and completely under the first Trump administration, the judicial nominations process has been given over to this conservative activist judicial, the legal and judicial organization, so that they come up with a slate of nominees that they gave to President Trump, essentially, maybe also the Heritage Foundation, which is another conservative think tank. And Trump, pushed through as many of these as possible. He he filled an enormous number of circuit and district court seats, and of course he got 3 nominees for the Supreme Court. So just like the pure process in the United States is already, it's not institutionally protected. So if there is someone with ill will that doesn't have the independence of the judiciary as an ideal, then there's not a lot in the that's baked into the institution that can prevent that. The other thing I thought, when this is on the, on the downside, is that this Federalist Society and Federalist Society, like-minded lawyers, law professors, and judges have been evolving judicial philosophy that goes beyond mere party affiliation to things that are to a very complex and sophisticated approach to the Constitution. So when the Polish judges held up the Constitution as a counterweight to the power grab of the Law and Justice Party, that isn't as easily done, because what we have now are 2 competing versions of what the Constitution means. The Federal Society version of original Constitution, where the goal of interpreting the Constitution is to go back and look at the original meaning of the Constitution, and the more liberal view of the living Constitution, where the interpretation of the Constitution evolves with changes in society. So those are 2 aspects that struck me as making it harder in some ways. Also, the lack of any kind of backstopping legal process that the Polish judges had in the EU courts, because there's no supererogatory court to the Supreme Court in the United States. And the most extreme capture by authoritarians has been of the Supreme Court. Other courts, as we saw post the 2020 election, there was a lot of independence manifested in the way the courts handled the challenges to the election results that had been brought by Trump advocates. But the social, the cachet, or the esteem in which the Supreme Court is being held now by the public is lower than other courts in the system, although all courts have been decreasing in the esteem in which they're held by the public, with as populism and skepticism of all forms of elite have taken hold. But on the positive side, I do have a couple of thoughts about what might be done within the United States along the lines of what the justices in Poland were doing. First, I was really impressed by the emphasis on media outreach and going to the public. I think this is tremendously important, and all legal and judicial organizations that are not in the Federal Society camp should be doing this rapidly and full throttle, creating content, getting it out on social media. There's been a recent study by some journalists associated with Axios about how we don't have one media system anymore. We have 12 media systems, and there are different ways of reaching people through these 12 different media outlets, or not outlets, but spaces, media spaces. So those should all be looked at for the different approaches that they dictate. So if you're, Facebook and TikTok are different kinds of media spaces. Podcasts are different kinds of media spaces. So all of those should be explored for the kind of basic education in civics that is sorely needed in this country, because only 1 in 5 eighth graders, a little more than 1 in 5 eighth graders, are proficient in civics. There's understanding how the U.S. government works. Only half of all American adults can name all 3 branches of government, and a quarter can't name one. So this is a pretty dire situation that has to do with the decline in public education that has also been something that conservative-minded activists have been working on for decades now, and we need to do what we can and really need to get in the trenches about this. About the Supreme Court, it's very difficult because of the lack of a backstop to think about how to redress what has happened with the shift in balance of power. But I thought that one thing that there's a lot of consensus on, even among Republicans, is that we need an enforceable code of ethics for the Supreme Court justices, and that this is something that should be ginned up in public. And maybe there would be ways of like silently demonstrating supports for this when people go into the Supreme Court, if they, wore a certain kind of article of clothing or a certain color or, some way to show that, yes, I want this, I want there to be a code of ethics for the Supreme Court. That's like a minimal level. And then the Constitution, the originalism. I think there are a lot of things that have not been tapped into in terms of like illustrating what would it mean to return to the original Constitution, which thought that slaves were only 3/5 of a person, and that states that you were obligated to return runaway slaves. So these kinds of things I think should be illustrated much more could be illustrated very vividly in terms of demonstrations. But right now I know like the people are very, very disheartened, and but they need to take a breath, take these next 3 months, rest up, and try to come back in the beginning of 2025. Thank you.
Yeah, I think there's a lot to be said about it's catching your breath after, well, many people, as you know, have been struggling for a long time in their causes, and then to get set back like that. Yeah. Regathering yourself. But one thing, Elizabeth, that you highlight that I found so striking in the text as well was sort of the public educational campaign of the Polish judges. I'm especially fond of their appearances at the various festivals around the countries and the enacting of the trial of Little Red Riding Hood versus the Big Bad Wolf. I mean, what a brilliant way to increase civic knowledge. Marcin, you've been asked quite a few brilliant questions that I've written down and I don't want us to lose. But first, I want, before you engage with those, if we could just turn to the to our attendees here and hear from them and bring them into this conversation. We have 25 minutes left in our time here. And we have two cases, actually 3 from around the world, where we have Mahibullah Nouri saying, what are your thoughts on the current situation in Afghanistan? Given that the Taliban, one of the most oppressive and regressive groups, is in power, do you think civil resistance can still be an effective strategy? And Victor Perez in Venezuela is asking, what about the case of Venezuela? 25 years ago, the dictatorship kidnapped the judiciary, and today is absolutely subjugated. And I'll echo Ali from Pakistan as saying we're facing the same thing in Pakistan. So clearly, this is a topic for our times. Marcin, if you have any reflections when you look at these other countries, and if our panelists have any thoughts to share on that as well.
First of all, I would like to thank you for such interesting remarks connected with this monograph. Second of all, in order to reply to these questions concerning Afghanistan, I don't have any knowledge about Afghanistan. It's hard even to say how to resist against Taliban regime. So I don't want to even respond because I have no knowledge about it. So I have to refrain from that. About Venezuela and the judiciary, my first reflection is that it is really easy to destroy independent judiciary, and it is much more hard to restore it. This is what Poland is facing now. One part was resistance against these populist attempts to take over. But now, 1 year after, we can say after this democratic government, it's so difficult to restore rule of law because still there are so many constitutional clinches, like there is still president that is vetoing any legal reforms. There is still constitutional tribunal that is politically packed, and there is no way to enact any kind of law that would restore what was before 2015. Not saying about reforming judiciary in order to make it faster, etc. Yes, so my impression is that this is very hard to rebuild, reconstruct, or even build it like the judicial independence without like without a democratic system. Like I don't know how it would be possible to do it, and so this is only what I can say about Pakistan. About Pakistan, I have to say that when I was looking for examples of resistance, one of them was what happened in Pakistan 20 years ago, almost 20 years ago. And it was, I think it was very important also to show Polish judges that weren't aware that there were other examples of lawyers or judicial resistance in other parts of world. Because what is very striking is something that is happening in our country. It's a certain, like now we can see this populist playbook, but it wasn't invented like a year ago or something. It is still being played in many parts of the globe. And this is also important to notice that all efforts to resist are also similar. That is why I think we can use those forms, especially when we are talking about non-violent protests. This is very important to see how we can adapt in geographical circumstances. Yes, using what is possible on the spot and trying to broaden the boundaries, like to see what's more, what can we do more.
Thank you, Marcin. We have with us today Michael Beer, who wrote Civil Resistance Tactics in the 21st Century, and whose framework was foundational for Chapter 6 of this book. So, Michael, you had asked a question in the chat, but feel free, if I'm clicking allow to talk, I invite you to just ask your question live for us, and you'll have to unmute yourself as well. We would love for you to share your comments and ask your question. And we can't hear you just yet.
Can you hear me now?
Wonderful.
Yeah.
Yes, Michael, it's good to hear your voice. I turn it over to you.
Well, Martin, congratulations on this important monograph. You may be the first person to use the updated typologies of nonviolent tactics and methods that I put together, and to analyze a nonviolent resistance campaign. What were the strengths and weaknesses of using this typology, and do you recommend it to others?
Thank you very much. I will respond very quickly. Like, what were the strengths? You could see that it could help to show like any kind. It would also like forced me to think about what ways, what kind of resistance. Sometimes I didn't consider like some of the actions that there were like resistance actions, but when I saw your typology, I realized that it's also very important to notice like the psychological help, these acts of support, etc. But one of the things that wasn't used, I will tell you, in your typology at all. Like I couldn't find any action, and I think it's also very common for these polarized societies. It was refraining, not doing, acts of omission, refraining, halting or calling off a planned or ongoing actions to reward or persuade. And there was no dialogue between the government and resisting judges. So there was no platform even to reward or persuade here. So this kind of actions weren't used at all. So this was only what I noticed here. But thank you very much. It was very inspiring. And I'm also like now I'm writing a paper about resistance of prosecutors, and I'm also using the same typology. So just to tell you how useful it is.
Excellent. Another question we have, and I'd like to tie it to one of Elizabeth's questions, is did the UN or international lawyers play a significant role, or was it overwhelmingly just EU-related judicial solidarity? Let's tie that to Elizabeth's question about the sort of the external pressure of the EU and the fines that was being levied against Poland, and the internal pressure of the judges' resistance and the popular civic resistance that happened at the same time. What are your thoughts on that, Marcin?
It's like one of the tactics was to publicize what was happening in Poland, like to make aware not only like actors in Poland, but mostly in Europe. But also, I know that on the UN level, there were meetings. So informal judges from the judicial associations were informally meeting with the representatives of European Commission, of the Council of Europe, and also with the UN representatives, just to show what is going on in Poland, just to make aware everybody. Yes, so it was one of the most important parts of the tactics, to make it European case, to show that it might happen everywhere. It happened in Hungary, it is happening now in Poland, and now we have tendencies like Slovakia, and other like Slovenia, maybe Romania. There are other tendencies to that they would like to do something with the judiciary as well. Yeah, there is this problem in the polarized society, especially. It is really easy to show that judges are our enemies, especially that there are a sort of allies. Yes, so it became a European concern, and you have to also be aware of the fact that EU in the beginning, they didn't have tools they didn't even understand, I believe, how to act against such a situation when one of the members such violently is acting against the EU values. Yes, so you could also see how EU was developing its tools like to respond, and there were like many of them, especially this conditionality mechanism, like because they realized in the end that what was the most important for those autocratic regimes was money. Yes, so they started freezing funds like recovery funds. They connected it with rule of law. They said without rule of law you won't receive these recovery funds after COVID. Yes, that were crucial to come back to the situations before COVID. Yes, and it had like Polish government, they responded, we don't need your money. We don't need your money. We have our money, we don't need yours. But in fact, there was this pressure that led to the situation that the disciplinary chamber was dissolved. in fact, the new body was very similar to the former one, but they did it, yes. And also like Supreme Court judges were restored. Then those judges who were repressed, they came back to the bench. They started judging. So it was really like there was a certain pressure, but there were also other factors. But it was very important that EU took part in this process. Yes. So yes, this is the response.
Thank you. Can you speak to Elizabeth's question on the lack of their willingness to resign? You had mentioned only 2 judges resigned, and that speaks to a faith in the system working. And is there a point at which that would crumble, or how, from a strategic point of view, then let's tie it to that, for people and judges and citizens who are going through the same type of struggle in other countries, how do we think about that question of the system and a remained faith? And I think that's especially pertinent to what Elizabeth mentioned about, faith in the courts in the US is on the decline, particularly the Supreme Court.
I was asking this question to judges. Why would you judge? Why would you stay in the office when the situation is so tense and you are attacked and you are risking your whole professional career and you have disciplinary proceedings ongoing, so you have to protest on the streets? Like, isn't it better just to have better life, just to have a normal life, etc.? Yes, and they were saying that it would be the last like they didn't even take into account this because they were aware that it would make it much easier for the government if they resigned, because those posts would be taken by new people that would come and that would owe something to the government because they participated in this proceedings, unconstitutional nomination procedure. So they decided to fight until the end. Like I was talking with one of the most repressed judges, and he said that after a certain point, he was not even thinking about the repercussions of his actions because he knew that what he was doing was right. And they also realized that judicial position gave them so much power, like everybody's aware. And I think that not everybody, like the government wasn't aware how powerful is judicial power, that this is the third power and there is not by accident. It has real power and they used it. And they also realized that having this power is connected with the job they are still holding. Yes, so it was important to stay until the end. And they said that we will stay until the end. They could remove us and it would be the only reason, but we won't resign because it would be the defeat that they given with this without any fight. Yes, so it was very important for them not to resign. So most of them didn't resign. Those who resigned, they had their issues. One of the judges was one of those who were targeted before judges started resisting. That's why he resigned, because he did not receive any kind of solidarity. It was before judges started protesting. Yes, so he was one of the first targeted, and without any signs of solidarity, he resigned because it was too much for him. Yes, but afterwards, it was completely different. Those judges, they really felt the support. So, yeah.
Thank you, Marcin. Another question from our community is, how did the business community respond to the threatened judicial system, particularly with regard to civil disputes? And after sharing your thoughts, Marcin, I would like to share it with Elizabeth and Doug from the perspective of what role do you see the business community as having in cases like this where the judiciary is threatened for its independence?
Very interesting questions, like the role of business community. I didn't see it much I didn't see it much. Maybe when there were donations for the movement, or there were like the donations for judges that were deprived of salaries. But I think that one of those that I could see was the decision, yeah, because the law proceeding, like the law proceedings that were at the time, they were also judged by so-called neo-judges. So it was to the business community to decide whether they will question the status of these judges or not. And if you will take into account that in November 2023, when the pilot procedure in case Wałęsa versus Poland started, there were already more than 500 cases in the European Court of Human Rights connected with the so-called participation of neo-judge, among others, yes. And one of the first cases was Xeroflor, and it was a business company like responsible for grass that they were questioning the constitutionality of the law concerning some kind of tort law, etc. But their case was judged by the Constitutional Tribunal, where was one of the judges that was elected contrary to law. So they questioned it, and they went to the European Court of Human Rights, and they won. And it was the first case concerning rule of law in Poland, and it was Xeroflor's against Poland. Yes, so I could see the role, like by deciding that they will protect those values. Yes, because I know, and here I could, like, some of them of course did it, some of them not, some of them used it like very just to support their cases. Yes, but I didn't see such a support. I didn't see it.
Doug and Elizabeth, any thoughts on the role of business in judicial matters?
Well, the ethics code that I was mentioning would be to try to obviate the negative role of business, because it has been revealed how that Supreme Court justices were accepting lavish gifts from business community leaders and not disclosing them, or not recusing themselves from cases in which they might have conflicts of interest. There were some, it's not quite judicial, but it's in the ballpark of the question. There were many promises made by business community after the murder of George Floyd and the demonstrations related to that. But it's hard to keep the business community focused on things. So the follow through was not great. And I would, I think that getting judges more out into the community and talking to people, there might be things that emerge that I'm not able to imagine just at the moment, but right now I feel in general that judges are kind of sequestered in their chambers, in their rooms. I mean, you see a rare interview here and there, sometimes if it's a retired judge, but they're very much kind of anonymous, unless you're actually in court. So I just come back to that, I think.
Yeah, I think what I'd say is that I think that business ought to be concerned with the independence of the judiciary, because, you know, without an independent judiciary, you can't have even, independent determination of even commercial disputes, etc. But I think very often it is the case that businesses are either playing a negative role, as Elizabeth has mentioned, or playing sort of a complete a very, very little role, as Martin has said. I mean, certainly that's our experience in Zimbabwe, that that business doesn't want really to have anything to do with human rights. Generally, they want to just keep in bed with the regime, or they're fearful of the regime. But I think one role that I think they can play, even in such contexts, is to provide that behind the scenes support for the movement. So that's positive to hear that there may have been such a role in Poland.
Thank you. We are coming to the end of our webinar, so I wanted to give our panelists and Martin an opportunity for closing remarks. Elizabeth, I'll turn it over to you, and then Doug, and then Martin, if you could share the closing words. If we have about a minute for each of you. Thank you. Elizabeth.
Well, I would just say that this is an incredibly important topic. I noticed in the chat, some people were reaching out for support or further contact. Please, Bruce has put the contact information for ICNC. If you want to reach me, he can refer you. And I would welcome staying in touch or helping in any way possible. I don't have anything much beyond what I've already said, but I really love the piece, and it's given me ideas for some next steps for analysis, and just thank you.
Thank you, Elizabeth. You've already brought so much to the table in this discussion. And now I'm going to be, since we couldn't quite get to it, I'm going to be digging into the positivism and natural law, all of it. So thank you for your rich contributions to this discussion.
Sure.
Doug, any
Sure.
closing remarks?
Yeah, I'll address my closing remarks to I've seen colleagues online from Venezuela, Afghanistan, Pakistan, the more authoritarian contexts with highly compromised judiciaries. Just to say, I think that there is a role for civil resistance in every context, no matter how oppressive. Certainly, it's not easy, but there is a place for civil resistance, and that the courts will remain a site of struggle in any context. In part because sometimes activists are the ones being dragged to courts. And so no matter how compromised a court is, we have to think, how do we grapple with it? It may be unlikely in those contexts to see the level of active participation from judges themselves. But I think that there's a huge amount to glean from Martin's research in terms of the role that civil society movements, lawyers, etc., can play in seeking to push back against the abuse of a judicial system, or the weaponization of a judicial system. And so, yeah, I would encourage all of you to go and read the piece and to produce more writing even in those contexts, in terms of how we can apply this framework in other contexts as well. So yeah, thank you very much, everyone, and thank you, Martin, for a fantastic piece of research.
Thank you very much for such kind words. It was really inspiring, the whole discussion, all the questions. I would like to underline in the end that the judicial resistance wouldn't be possible without the support of civil society and also the civil society organizations and other professions. Judicial resistance was possible because judges realized that their action is needed. Like they saw that protesting people, they wanted them to step in and say something. They wanted them to show that they are also fighting like on the same side. Yes, so it was really important to see that. I could see the relevance of that. Without this support, it wouldn't be possible. Yes, so and also in Poland, it all started with the people protested on the streets, not judges protested on the street. So I think that this is the most important lesson, yes, that without civil resistance, there is no room for any other kind like of this low legal professional resistance. So that's why this is important to understand that without all this background, I wouldn't have written this book, and judicial resistance wouldn't have taken place. Yes, so first what has to happen is this. Yes, so thank you. Yeah, this was also, and I think it is in this book that judges now, they owe the society, they owe it. In a way, they were supported, so now they should be those so-called citizens judges. Yes, those judges who really care about civic rights. Yes, thank you very much.
Incredible. Thank you so much, Martin. We've learned so much in this time together, but also in your study from Poland and from the strength of the people in resisting overreach and the authoritarian advance, both in the 80s and in the recent years. We thank everyone who has participated, and there's so much great discussions that happen in the chat as well. Wonderful links. Stay tuned with ICNC. Subscribe to our mailing list. We have an online course open to everyone around the world that is beginning in February. Reach out for that. Thank you to our amazing panelists for the wisdom, the insight, the experience that you've brought to this discussion. And we look forward to discussions moving forward beyond this. This is only the start as we continue to learn about this important field. So thank you to everyone. Have a wonderful day and keep in touch.
Everyone.